Senators, please take your seats. Saslaw. Okay, the committee will come, the Senate Judiciary Committee will come to order. The clerk will call the roll. Okay. Okay.
Quorum is present, Mr. Chairman.
Thank you. We have a quorum. First of all, I want to announce that we have two subcommittees. The Civil Law Subcommittee, chaired by Senator Peterson. The members of that committee will be Lucas, Normand, Obenshain, Chafin, McClellan, and Boysko. Civil Law Subcommittee. Senator Peterson will be the chair. Criminal Law Subcommittee, Senator Deeds will be the chair. And the members include Saslaw, McDougall, Stewart, Stanley, Serval, and Morrissey. And I will be a member of each committee as well, and with voting rights. Senator Deeds will be vice chair of the committee. I would like at this time, since most of the committee members are here, to have them introduce themselves, starting, I guess, with Senator McClellan, and it will come around like this and all the way over. How's that? Introduce yourself as a member of the committee, state your name and what district you represent, and anything else you think of that's interesting, but not your entire history. Yes, Senator Stanley, thank you for the very first time showing up.
Thank you. I'm excited about Gun Bill Day since you kicked it over to today. I really appreciate that.
I just want to say we hope you enjoy we hope you enjoyed Charlotte, North Carolina, since you were not here. Okay.
I did, but the defendant did not.
Yeah.
That's Machine Gun Stanley.
Okay.
Right.
Senator McClellan's going to give her life history.
No. Hi, I'm Senator Jennifer McClellan, represent the 9th District, which you're in. I represent the northeast part of the city of Richmond, eastern Henrico, all of Charles City County, the town of Ashland, and a little piece of Hanover.
Hi there, I'm Jennifer Boysko, representing the 33rd Senate District. That's the towns of Leesburg and Herndon, Dulles Airport, eastern Loudoun, northwestern Fairfax County.
Good afternoon. My name is Joe Morrissey. I represent the 16th Senate District, which is all of the city of Petersburg and Hopewell, portions of the city of Richmond, Chesterfield County, Dinwiddie, and Prince George. And I think I should say this right now rather than later. The gentleman to my far left, William Stanley, Senator, I'm going to remind him now, in case he thinks of doing this later on, that there is an attorney-client relationship between he and I, and he should be careful with what he says about me.
Love it.
Okay, Senator Serval.
I'm Senator Scott Survell. I represent the 36th Senate District, Prince William, Fairfax, Stafford County, and in 23 years of practicing law, I've never, ever lost a trial, ever.
Anybody believe that?
Just kidding.
My name is Chap Peterson. I'm Senator, 34th Senate District. My wife and I own a law firm in Fairfax City, and I've lost a couple, but not many.
Eloise Lucas, representing the 18th Senatorial District, and I didn't do it this morning, so I'll do it this afternoon. It's all a part of Portsmouth, Chesapeake, Suffolk, Franklin, Southampton County, Isle of Wight County, Greensville County, Emporia, Brunswick County, Sussex, and Surrey. That's it.
I have the rest of the state. The Dick Saslaw 35th District, which most of it is central Fairfax, with the exception of a small part, and that's inside the Beltway, and I have Merrifield just outside the Beltway, the city of Falls Church, and 4 precincts in the west end of the city of Alexandria.
Okay, my name is Senator John Edwards. I represent the New River Valley and the Roanoke Valley, the most beautiful part of Virginia.
Where's that?
I'm Creed Deeds. I represent the 25th District, which is Highland, Bath, Allegheny, City of Covington, cities of Lexington and Buena Vista, Rockbridge, Nelson, City of Charlottesville, and Albemarle.
I'm Tommy Normant, and I represent the 3rd Senatorial District, which is a historic triangle area, and I'm the only real country lawyer up here.
Old country lawyer. My name's Mark Obenchain, and I listened to Senator Sasslaw say that he represents the rest of Virginia. I remember a politician up in Northern Virginia a few years ago saying that Virginia is really 2 states, Northern Virginia and Alabama.
That was me.
So those of us down in Tuscaloosa represent the rest of Virginia, not Northern Virginia. I'm proud to represent the Central Shenandoah Valley, the 26th Senate District, the gentle fold in the palm of God's hand.
I'm Ben Chafin. No big deal. I'm Ben Chafin, and I represent the 38th Senatorial District. I represent the people that live in the northern part of the landmass of Southwest Virginia that stretches from Montgomery County to Kentucky and West Virginia.
I'm Senator Bill Stanley. I'm Senator John Edwards' best friend. He's never let me down in my life. I represent the 20th Senatorial District with the South Side and Southwest Virginia. Includes Patrick County, Carroll County, City of Galax, Martinsville, Henry, Franklin County, Halifax, Danville, Pittsylvania County, and South Boston. And I just want to say, when it comes to being an attorney, I'm the best that ever was. Nobody can hang with my stuff. That's Ricky
Okay.
Bobby.
Does anybody else want to say the
Nobody
truth?
can chase an ambulance like him.
Okay, thank you all very much. So now everybody knows who the members of the committee are. The first thing we're going to take up is the judge certification. The committee interviewed.
Lights on in here.
Yeah, do we have better lights in here? I don't know. The committee will take up the certification of current judges seeking reappointment. A list of the, there we go.
Let there be light.
Yeah, a list of the incumbent judges with terms to expire in 2020 has been distributed to each member. These judges interviewed before the Joint Committee for Courts of Justice prior to the start of the session on December the 6th, 2019. So take a minute to look over the judges. The committee will take up these names in block and will operate by voice vote. If any member wishes to remove a judge or justice from the block and vote separately, please do so at this time. Is anybody would like to remove at this time? Yeah, Senator Morrissey.
Thank you, Mr. Chair. Under Circuit Court's 6th Circuit, would you remove from the block W. Allen Sherritt?
Okay. Is anybody else? W. Allen Sherritt, Sharrett, 6th Circuit. Anybody else want to remove a judge at this time from the block? Okay, if not, we'll entertain a motion to certify the remainder of the judges as the Justice of the Supreme Court, Circuit Court judges, General District Court judges, and Juvenile and Domestic Relations District Court judges. Any discussion? All in favor of the motion to certify those judges as qualified, please vote aye. No? Say aye, I'm sorry. You don't need a voice vote. Say aye. Any opposition? If not, okay, that's unanimous. Thank you very much. So these judges will be certified as qualified for their respective judgeships as listed on the list.
Mr. Chairman?
Mr. Chairman? I'd like to move to certify Judge W. Allen Sherritt.
I second that.
You want to do what again? I'm sorry.
I want to move to certify.
Okay, all right, you want to reconsider the vote?
No.
Oh, separately, okay, all right, okay, you're right. All right, there's a motion to certify 6th Circuit Judge W. Allen Sherritt.
I thought we just did, didn't we?
No, he was taken out of the block. There's a motion and a second.
Mr. Chairman?
Yes.
Mr.
Yes, Senator Morrissey.
I certainly understand and respect the motion by the senator from James City County. Isn't it traditional when these names come up on block, if a senator within that circuit has not met or spoke with that individual and is desirous of doing so, that it's customary to remove him from the block, and it doesn't prohibit him from later being certified.
Does anybody want to respond to that? Senator Norman's out there talking to somebody else.
Mr. Chairman,
Yes.
what I would maybe suggest is that that motion simply go by for the day, the motion to certify Judge.
Without objection, the motion will go by for the day. Okay. All right, without
With the
objection.
understanding it's going to be revisited.
Yes. Okay. All right. So now the first bill we will take up, I promised Senator Peterson to take up Senate Bill 209. Senate Bill 209. There are two General District Court judges from Fairfax County that would like to speak, I understand. This has to do with increasing the maximum number of judges in Fairfax County. Senate Bill 209. Senator Peterson, you have the floor.
Thank you, Mr. Chair. Mr. Chair, members of the committee, this is Senate Bill 209, which deals with the allocation of judges in the judicial district. This is the 19th judicial district, and it strikes the word 11 and adds 12, so we're adding an additional general district court judge.
Okay.
This has been a recommendation on the Committee on State Courts. It's been a recommendation of the Supreme Court. We actually passed this exact same bill, I believe unanimously last year, and it was not in the budget, which is why I'm back again this year, so it was kicked out for that reason. The money is in Governor Northam's budget, and again, I'm just coming forward again, and I've got Judge Lisa Main here who came down from Fairfax. Judge Capsalis went over to the other body, but Judge Main can talk about why we need an additional judge.
Okay. Yeah, thank you, Judge.
We got a-
First of
for me
all,
or for-
question to the patron, Senator Norman.
Yes, sir.
I know why it was not funded last year, and I had made this comment to the judge.
We turn the light.
Yeah.
Yeah. So can't hear you.
I apologize. I said I know why it was not funded last year because I was sitting on the Finance Committee that dealt with it, and I said something to the judge. Do we know where it falls in the matrix of priority of judgeships to be funded?
Well, I know that it's, I believe, the only one the Supreme Court has recommended of the General District Court bench to add. And again, Judge Main can speak to that more specifically. That is the information I have. Judge Main.
Mr. Chairman and members of the committee, the way that I would answer that question is that the judicial workload study came out with a number of 12.07, I believe, that then they did the math and we got bumped down to 11. But we were in that percentage of, I believe it's 1.10 to 1.2, where the report said other factors could be considered, and we went in front of the Committee on District Courts, which I believe, Senator, you are a member of. I think Senator McDougal was that day, but was there that day, but I don't know if he was there for the presentation, and we received a certification from the Committee on District Courts that the need was great.
Senator Norman.
I'm trying to help you. There are some new members that are on that Finance Committee, and I know the details of it, and I was hoping they would listen and maybe you could help educate them, because it was just sort of a rounding down that caught you.
That is correct.
Right. I apologize. You were trying to give me a softball, and this is when lawyers and witnesses don't prep ahead of time, so. Okay.
I'll leave you with basically three statistics that kind of give you an idea of what we're facing. The caseload in Fairfax is 37% higher than the average caseload per judge statewide. And at 15 judges, 4 more than what we currently have, Fairfax would remain above that caseload average per judge. Our first available trial date for a blood docket case for a DWI, if you came in today, I could give you a trial date in August. It hardly seems fair. That's because those dockets are capped at 10 defendants per court date. It hardly seems fair that a defendant should have to remain under the auspices of a criminal charge for that long, or that a law enforcement officer would have to testify about something that happened over a year ago. And then finally, on a daily basis, half or more of the judges are assigned to hear traffic cases, which consist of 100 to 200 cases, including 4 to 11 DWIs. If one of those DWIs goes to trial, the judge isn't going to have lunch and may not make their 2 o'clock docket. If 2 of them go to trial, they're definitely not going to make their 2 o'clock docket. It frequently happens that they don't. Dockets have to get combined, or in the worst case, cases get bumped.
Okay.
We need the judge. We're asking for your support.
Okay, any further discussion? Anybody else to speak?
Mr. Chairman.
Is there a motion?
I think we're good.
Yeah, I think we're good.
Is there a motion to report?
I
Senator
move.
Peterson?
Second.
And Senator Norman? Huh? Yeah, and be re-refer to finance. All right, all in favor of the motion to report Senate Bill 209, vote aye. All opposed, vote no. And let's see, how do you? Do I push this? Okay, okay. Stewart, okay. The motion passes, or bill is reported by a vote of 14 to nothing. Okay. Thank you. The next bill will take up Senator Stanley as number 1. We need to do him a favor. Since he wasn't here, he's in Charlotte having a good time on Monday, not doing his senatorial business. Is there a motion that we roll?
First, I have a substitute. Should you do the substitute first and then roll, or roll and then
Let's
sub?
roll them in first.
roll.
Rolls my bill, Senate Bill 514, and Senate Bill 10, Senator Evans' bill, into Senate Bill 1. That's a motion. Second?
Second.
All in favor of the motion? I think we have to roll call vote. All right. 814?
Everybody wants
I don't have an
credit.
814 here. 814? Yeah. Okay. Senator Morrissey's bill. All right, 814. So we got 4 of them. 814, 514, 10, and rolled into 1, Senate Bill 1. All right, all in favor of the motion, say aye.
Aye.
Aye. Vote aye. All opposed, vote no. And Lucas, you got Lucas? Okay. The motion, go ahead. The clerk will close the roll.
Ayes 14-0.
Okay, the motion carries by a vote of 14-0. Now, there's a substitute?
Yes, Your Honor. Your Honor. Yes,
That's
Mr.
okay.
Chairman. I'm still not back from North Carolina mentally yet. Yes, Mr. Chairman, members of the committee, there's a substitute.
Would you like to explain the difference between
Yes,
the substitute?
Yes, Mr. Chairman, it's better.
Okay.
Basically, what we do is remove some of the concerns that the DMV had with regard to the non-resident violators compact. It also contains an emergency enactment clause, and I can explain why. I think there's a reason for having this it will have to be a 2/3 vote in the Senate, but I think it's warranted for having an emergency clause. And then there's 46.2361 deals with restoration of driver's license for failure to furnish proof of financial responsibility or uninsured motorist fee. Fourth, it creates a presumption of when an individual signs a summons, they acknowledge their failure to appear and failure to pay court fines will result in suspension license. So we need to straighten that up because courts will no longer suspend license just for
Okay.
failure to pay fines. and
The
fees.
public interest, this is the bill regarding suspension of driver's license for non-payment of fines or costs.
Yes.
So the license will not be suspended going forward for non-payment of fines or costs, and it fixes a number of technical errors.
Yes, Mr. Chairman, members of the committee, we've adopted the substitute, I'm assuming, so I will speak to the substitute. Ladies and gentlemen, this bill I have brought for 4 years, and I have finally seen the promised land, and it is in front of us because of what we did last year. And I think if you recall, those in the House had the problem because they said if we pass this law, we will no longer have people paying their fines, and they said that the sun would fall from the sky. Well, now we've had 40,000 plus Virginians restored automatically of their driver's license. The sun did not fall from the sky, and the fines are still being paid. What I can tell you from the result of having it in the governor's budget, not only did we have overwhelming bipartisan support in both the House and Senate when it finally got to the floor of the House, but more importantly, what we've seen is that it has brought dignity and respect back to those Virginians who have been put in debtor's prison by the state merely because they cannot afford, they have to make a decision with that fine of whether they're going to put food on the table or pay that fine. Ladies and gentlemen of this committee, I will remind you that many times my clients go into a court, get a $25 fine, and get $90 tacked onto it because of what we do. Adding courthouse security fees, this fee, that fee. And pretty soon that $25 fine turns into a $115 fine. And 115 is a lot different, maybe in my area than it is Northern Virginia, but it's not fair then to say, although you're not suspended for your driving behavior, you are suspended for your financial station in life. Ladies and gentlemen, I can also tell you that I've worked in indigent defense in my area on driving on suspended cases to try to get people on track before we had this. And the greatest thing I think in the 10 years that I've served in this body has been when I was in a store and a woman who had been a client of mine came up crying, holding her license. It was the proudest moment for her as it was for me. Ladies and gentlemen, it is time to stop this arcane practice of suspending one's dignity and one's license because they cannot afford at the time to pay their fine. The end result is that what we're doing is we're detaching people from the community. We are creating people that must live in the shadows in order to continue to drive to go to work. We are doing something, quite frankly, which is not only un-American. Quite frankly, it is not right for Virginia. And we have seen no decrease in the payment of fines. We have not seen anything that the Republicans on the other side in the House said was going to happen. And in fact, what we've seen is more productivity. What we're trying to do, ladies and gentlemen, is to remove government dependency from people's lives. When you take their license, then they lose their job, then they must be dependent on the government in order to survive. That's not right either. And quite frankly, when we look at this also, not only do we create that dependency, what we're trying to accomplish is creating an independency. But more importantly, and I think even better for us, is that we want people to be productive members of the community and not live in shame because of their financial status. And let us not forget that we always say that a driver's license is a privilege. Well, Supreme Court disagrees with you in one sense. It is a privilege only in the sense that you must be 16, pass a driving course, and then take a test. But the Supreme Court of the United States has determined that once you obtain that license, it is a property interest. And deprivation, as we have done, of that property interest without due process is a violation of the Constitution that protects us. And for those reasons, ladies and gentlemen of this committee, I would submit to you that we must do what is right now winding through our federal courts, and that is to remove this arcane practice from the Commonwealth of Virginia as a policy decision alone. The upside is that will render that federal court case moot. That is part of the reason why there's an emergency clause on this, and so we can stop that lawsuit and we can put people back to work and being productive and back on the roads. We can make sure that they'll want to get insurance for their vehicles because now they have their license. We'll ensure that they want to work because now they have a way to get to work. Thank you, Mr. Chairman.
A federal judge did rule it's violated equal protection, Judge Moon.
Mr. Chairman, members of the committee.
Preliminarily.
I would submit that a preliminary injunction has already been granted by that judge in the federal court, Judge Norman K. Moon, stating that that was a property interest. And what we were doing by not bringing them in before we suspended their license and merely having them sign a piece of paper when they acknowledged that the fine was owed, that was not enough due process to deprive you of the property interest that you lost. Because as you know, Mr. Chairman, I'm sure with your clients in mind, I've had clients that were paying the fine, but the check was mailed in, but was not received on time, received 1 day late, their license is suspended. They think nothing of it. They keep paying the fine. And then all of a sudden they get pulled over and find out that their license has been suspended. And oh, by the way, you had notice because you signed this piece of paper. And now they've got to go back in for another event before the tribunal. They've got another fine. and they have sometimes a risk of jail. So I think it's the right thing to do, and it's been 4 long years. I want to thank Amy for all the work. Amy Willard has done an amazing job with this as well. She shares the passion that I have about this, but the time has come, and it is now.
Anybody else? Any questions, Senator Norman?
Mr. Chairman, if I may, can I change this from Senate Bill 1 to Senate Bill Awesomeness?
You could.
Is that a friendly amendment?
In your own mind, you can.
Okay, thank you.
But not in the record. Yeah, Senator Norman.
I appreciate your altruistic passion, but there are some courts and some Commonwealth attorneys around the state that employ private attorneys to collect unpaid fees and cost. And is this going to result in increased collection efforts through clerk's office and Commonwealth attorneys who are going to have to bring civil suits to collect this money? I don't think that pending court cases address that.
Mr. Chairman, I'd answer the gentleman by saying we already have various avenues. As we know, fines can operate as a civil judgment and can be executed on. The Commonwealth's attorney, we actually lengthened the time, if you know, by one of my bills from 30 days, I think, to 45, because we saw the payment range was usually around 45 days to try to give them some relief before it was referred to a law firm, a private law firm for collection. There is a way that the court could bring them in on contempt if they really wanted to do that for non-payment of fines. That is an inherent power of the court when that order is violated. Mr. Chairman, I would answer the gentleman by lovingly say I have a firm belief that this bill will not affect his law practice in collections.
How many Virginians now cannot drive? The license is suspended because they didn't pay the fine and costs.
Mr.
Right.
Chairman, the answer to that is nearly 750,000 people.
Okay. All right,
In state and out of state who had possessed Virginia driver's license.
We need a motion to adopt the substitute first by voice vote.
I'll make that.
Motion made and seconded. All in favor of adopting the substitute, say aye. Aye. All opposed, no. Motion carries.
I move the bill be reported.
Motion been made for the bill to be reported. Does administration or somebody want to say anything? Anybody else want to say anything? You like it? Administration
Well,
strongly
that's the
supports
kiss
the
of death
bill.
right there. You guys should have just shh. Administration
The
supports.
bill has to go to finance, so the motion,
Mr. Chairman, if I may say, there's a component in this bill which makes it not have to go to finance, because in the governor's budget was the payment of the reinstatement fees, the $145. So my
I
understanding
take
is,
directions from the finance committee. They want to look at it for some reason. I don't know why, but they do.
oh, Mr.
That's what I've been told.
I don't think your bill's in trouble.
Okay.
You're okay, you're in good
But this
shape.
will have no financial impact. Quite
All
frankly,
right, the
to
motion's been made and seconded that the bill be reported and re-referred to finance. All in favor of the motion, vote aye. Opposed, no.
Look, I just voted for you.
The clerk, your clerk will close the roll.
Ayes 14, no 0.
The bill is reported by a vote of 14 to nothing. Congratulations.
Thank you, Mr. Chairman. Thank you, members of the committee. For
You
your
get a special red star or something.
Senate Bill Awesomeness. Thank you, sir.
Awesome. Gold star. Okay, before we continue, there are 2 bills that need to be stricken, I'm told. Senator Sproul has Senate Bill 51 relating to carrying a concealed handgun, consumption of alcohol in a public park penalty. Is there a motion to strike that bill from the docket? There's been motion made and seconded by Senator Saslaw to strike Senate Bill 51. All in favor of the motion, say aye. Mark, vote aye. All opposed, no. All right, the clerk will close it. The clerk.
Ayes 13, no 0.
All right, motion carries 13 to nothing. There's a second bill to be stricken, Senate Bill 267, Senator John Bell, limitation on recovery, manufacture, distribution, or prescription of opioids. Is there a motion made and seconded? Senator Saslaw seconds the motion to strike Senate Bill 267. All in favor of the motion, vote aye. All opposed, vote no. The clerk will close the roll.
Ayes 13, no 0.
The motion carries 13 to 0. 2 bills are stricken. We're making progress. I would also like to announce that we're sending several bills to the Civil Law Subcommittee that Senator Peterson is chairing. And these are as follows. Number one, Senate Bill 28, Senator Peterson's bill regarding eminent domain. Senate Bill 31, Senator Peterson, another eminent domain bill. Yeah. Senate Bill 208, Senator Peterson's mechanics lien bill. Senate Bill 229, Senator Peterson's signature defects on pleadings, motions, and other papers. Yes, just about. There are other people on the committee, by the way. You'll get outvoted, maybe. Senate Bill 253, Senator Chafin's bill, deeds of trust, fiduciary duties. Senator Chafin's bill. Senate Bill 261, Senator Chafin's bill regarding accounts filed by fiduciaries and reports filed by guardians and a penalty. Senate Bill 285, Senator Deeds' bill, bystander claims for intentional or negligent infliction of injury or death, emotional distress. Senate Bill 285, Senator Deeds, 308, Senate Bill 308, Senator Stanley's bill, accounts filed by fiduciaries and reports filed by guardians, perjury penalty. Senate Bill 485, Senator DeSteff's bill on eminent domain, remnants and remainders. And Senator Obenshain's bill, Senate Bill 951, regarding eminent domain, written offer to purchase property. You see a pattern here? A lot of eminent domain bills. That will
I
go
move
to
to
Senator
report.
Peterson's subcommittee. Okay, any questions about that? That'll be reported. All right, we're getting rid of a lot of bills here. All right, the next bill we're going to deal with, yes, we got some signups here. All right, Senator Eben. And this is marijuana?
Well, before we get to that, Senator, Mr. Chairman, I've got three bills, and I wanted to roll my bill, SB 19, into Senator Sutherland's SB 62, removing the race designation from the marriage form. He's got more comprehensive language, and he's here to present that, if that's okay.
Okay, so that would be Senate Bill
19 rolled into Senate Bill 62 that Senator Sutherland is with me here.
Okay, Senate Bill 19 of Senator Eben rolled in, wait a minute. Yeah, Senator Bill 19, Senator Eben, records of marriages, identification by race, rolled into Sutherland's Senate Bill 62, is that right?
Yes, sir.
Okay. All right, is there a motion that we roll in Senate Bill, let's see, Eben's 17, is that right? I'm sorry, 19. Senate Bill 19 rolled into Senate Bill 62 with both senators being chief patrons. Okay, is there a motion that we do that? To roll them? It's been moved and seconded. And it's got to be a roll call vote. All in favor of the motion, vote aye. All opposed, vote no. All right, the clerk will close the roll.
Ayes 12, no 0.
Okay, 12 to 0, is that right? Okay. The motion carries. Okay, who's going to speak? Senator Eben or Senator
We're
Sutherland?
going to have Senator Sutherland speak, if that's okay.
Okay, that'll be fine. All right, Senator Sutherland.
Thank you, Mr. Chairman. Senate Bill 62 is now before you. What it seeks to do is eliminate the requirement that the race of the individuals in a marriage party be included in the marriage records, the divorce records, and annulment records filed with the state registrar. And it also removes the requirement that the registrar include that information in reports about such things. And so if you just had Senator Eben's bill in front of you, the first 47 lines are identical, and what the only difference what my bill additionally has is the additional code sections making clear that we're also going to have the same effect on divorce and annulments and also on the reports related to them. Sure, Senator Edwards, you know we had the court case in our part of the Commonwealth about this. It was how a lot of us found out that the Commonwealth was still asking for this information because it was required by the law. It's something that's been in and out of the code for about 110 years. It got taken out of the code, and then it got put back in the code in early part of this century. And it was put in by a legislator that's no longer living. And so we couldn't ask him why that was a good idea. And so we had some conversations since then about if it's actually something that should still be there or not. And Senator Edmund and I believe it should not be.
Okay, any questions of the patron? Anybody want to speak in favor or against the bill? Okay, here we go. The Attorney General himself. He looks sort of like the Attorney General.
Thank you, Senator. Mr. Chairman, Toby Heitens, the Solicitor General of Virginia. The Attorney General strongly supports this fix. I think like a lot of people, we only became aware of this provision of the code when a lawsuit was initiated in the fall, and although the Attorney General did the best that he could under existing law to attempt to ameliorate the problem, the court concluded that existing law required the question to be asked, so the Attorney General strongly supports removing this language from the code. Thank you.
Okay. Anyone else want to speak in favor or against the bill? I think it's in good shape.
Move to report.
It's been moved and seconded to report the substitute. It doesn't have to go to finance or anything. All right, all in favor of the motion to report the substitute, vote aye.
Aye.
All opposed, vote no. Okay, the clerk will close the roll.
Ayes 14, no 0.
Okay, the motion carries. Congratulations.
Thank you very much.
Okay. Now, Senator Distaff had some bills.
I had two more. Did you
Oh,
want him
I'm-
to speak first?
Oh, go ahead. All right, Senator Evans.
Okay, so on this next one, I'm representing myself pro se with Senator Norman as my co-counsel. This is SB2, the marijuana
trouble.
decriminalization bill.
Okay.
There's an amendment in the nature of a substitute, I understand.
Okay. This is Senate Bill
Two.
number 2, which is
Yeah.
marijuana.
And what the amendment in the nature of substitute does is it eliminates references to a central criminal records exchange, which is not needed for a civil penalty, and makes some other changes that I can go into if people have questions, but
Okay, explain the bill.
Sure. Okay, so we know the prohibition on cannabis in this country and the Commonwealth have failed, but also we have to consider that there are serious lifelong consequences for a marijuana conviction, even a 251 deferred disposition for those convicted and their families. We know that it impacts employment, in some cases driver licenses, higher education funding, or I should say financial aid, housing, immigration status, ability to purchase and possess firearms. And I think it's important to realize that this bill, decriminalization, is not legalization of marijuana. It provides a civil penalty, but there's no longer the threat of a misdemeanor or having to undergo an extensive ASAP program. There's negative effects, as I said, of current laws. They're widespread. More than 88% of all marijuana arrests are for possession, and currently there's random drug testing for those who are on supervised probation, which interrupts employment because they have less than 24 hours notice for that testing. Decrim will save law enforcement costs with an estimated $100 million in estimated enforcement costs in 2018 for 29,000 defendants. The penalties are not consistently applied. Some Commonwealth's attorneys do not even prosecute misdemeanor possession. The penalties disparately affect minorities. Black Virginians are charged three times more frequently than white Virginians, although they're estimated to use marijuana at the same rate. In one county, African Americans are charged as much as 10 times more often than non-black defendants. 83% of Virginians think it's time we get rid of this, and other states have done this, but I think it's important to realize that North Carolina, Washington, D.C., and Maryland, along with lots of states, including Mississippi, Missouri, and others, all have decriminalization laws, with D.C. being a legalization law. So one of the net effects can be that you drive in from North Carolina or D.C. Or even Maryland, and you think something you had wasn't that much of a penalty, and then you've driven into Virginia where you're getting a more significant penalty along with a potential criminal record. And I can answer further questions the committee may have.
What question I have, what is simple possession?
In this bill, it's 1 ounce or less is presumed for personal use, which I believe is a change from half an ounce or less that was before. 1 ounce, I'm told, is about 30 uses of marijuana, whereas the other is about 15. And we're changing the penalty as well, I didn't say this, to a $50 civil penalty for possession.
No longer a crime, no longer a misdemeanor, but a civil penalty of $50.
That's correct.
Mr. Chairman.
Yeah,
Mr. Chairman.
Senator Stanley.
Thank you. First, I want to say anybody who can smoke an ounce, from what I hear, and 30 uses is pretty prolific, but
You might buy like a 2-week or 3-week supply, I guess. I don't know how long it lasts.
this is just what I hear. I don't have any personal experience, but, so,
You wouldn't
Mr. Chairman,
know.
I'd ask the gentleman that, in this bill, I found, and I'm a co-sponsor on it, but what I found is that we're still treating possession, we treat possession now as a civil offense if you're over the age of 8, or you're an adult, it's 18 or 21. But you're criminalizing it still for children. That is, those under 18. And, you know, I could see that if it was totally legalized and then the possession of it is based on age. But is there any, you know, I'm a little confused. Why do we still criminalize it for minors when we've now determined it's a civil penalty for adults?
2 reasons. I was not thoughtful enough when I drafted the bill, and the senator didn't return my phone call when I asked what we should change. But I'm very open to changing that portion to whether it's juvenile delinquency or whatever it is. I mean, we just need kids to know it's wrong and not acceptable, and then provide whatever the consequences are that the committee comes up with. I don't know what you would recommend particularly.
Oh, Mr. Chairman,
Yeah, Senator Stanley.
I think we're talking about an act of delinquency or a chins or something that is less invasive as a criminal charge would be probably more my liking. I just don't think it's kind of fair. We're making it civil here, but not. And I'm not saying that we should make it civil for kids, but there's got to be some kind of play there. So I haven't thought it through because, you know, I can't focus enough like that, but I'm reminded of South Park, marijuana is bad, kids. So if we can just make sure that that's still a part of it.
Mr. Chairman.
Senator Sasslaw.
I remember back, John Dalton was governor when we first got to the half ounce provision, and he signed it. And even somebody like tough on crime as Bob Horan remarked that if you don't do something, he says, you better start building a ton of jails because we're going to be filling them up. So basically, I guess for lack of better description, it's high time we did something about this.
Mr. Chairman.
Yeah, Senator Senator Serval.
Mr. Chairman, I have a series of questions for the patron and then for council. Senator Evan,
Yes.
I'm on line 706.
I need to get a copy of the substitute if I can.
I'm on line 706, which has to do with expungement.
Yes.
Can you tell me what your intent was with regard to expungement?
Sure, that people could get their records expunged. In terms of the cost, I was told to expunge all past records in full would be a significant undertaking. So I'd like people to be able to expunge past records.
Mr. Chairman.
Yeah, Senator Serval.
Okay, so just so I'm clear, what it is you want to do, because I don't understand the language the way it's written, which I'll get to in a second. What you want to do is for anybody who has a misdemeanor conviction of marijuana possession before July 1, 2020, to be able to go back and get an expungement of that criminal conviction, notwithstanding the fact that they were convicted, right?
That's correct. I want them to be able to fill out a job application and truthfully state whatever under expungement that they don't have a conviction on their record.
Okay. Further question, Mr. Chairman. So Mr. Chairman, question for council. Okay?
Which council?
Either one. The way I'm reading, the way this has been written, it says, if a person is charged with the commission of a crime, which this is not anymore, or an offense defined in Title 18.2, which I guess this is, and then under 4, it says the person is convicted of a violation or such charge deferred and dismissed. I'm trying to figure out if that reads together. So if they're charged of a crime or any offense, under the code, I'm pretty sure offenses are not civil infractions. So it seems to me there's an internal conflict in the way the sentence is written. And I've had a lot of these, I've had some battles over expungements and over what's in and what's not with some Commonwealth attorneys over the last 10 years. I want to make sure we get this correct because I'm not sure the way it's been drafted, it necessarily accomplishes what we're trying to achieve because it has an internal inconsistency. Because I believe, at least under some opinions I've gotten from circuit court judges, offenses are only misdemeanors under 18.2. So we have, and can somebody enlighten me on that?
Senator Norman. No, Steve Benjamin.
Mr. Chairman, I think the senator is correct that we need to make some word changes here. I'm also still not certain what the patron intends as far as expungement. Is it the patron's intent, Mr. Chairman, that someone who has been convicted in the past of such an offense be able to have that expunged from their record?
Yes, so perhaps it should be under 707, on line 707, something like has previously been charged. Or,
that's not the, Mr. Chairman?
Yeah, Senator Serval.
Thank you. And I had the same concern about the use of the verb is in the expungement provision, because the way I read it, it would only apply, I could see a judge saying it only applies prospectively because it talks about is and not was. And so I had that concern as well. And so I think this entire section needs to be reworked, but I think the first thing we need to do is ascertain what the intent of the patron is, and secondly, what the intent of the committee is, so that council can write it the way we mean it.
yeah, I don't see any need to expunge people who, I mean, there won't be a criminal conviction in the future. If it's less than an ounce, it would be a civil penalty, so there wouldn't need to be an expungement of those future charges after July 1st.
Mr. Chairman?
This past ones.
Yeah, Senator Serval, you want to pass this back for the day to fix it or what?
Yeah, and could I just point one other thing out really quick? Mr. Chairman?
Yeah, Senator Serval.
Is it the patron's intention that in the future, if somebody's charged with a civil infraction of marijuana possession, and that charge is dropped or dismissed because somebody's not guilty, that person should be able to obtain an expungement like they could today with a criminal charge? Because the way this is written, you can't.
Mr. Chairman, a couple of things.
Yeah, Councilman Norman.
And I understand exactly what Senator Serval is saying, and the objective is to allow an expungement for someone that has previously been convicted of a simple possession of marijuana when it was a Class 1 misdemeanor offense. That's the objective. I think I concur with you and with Mr. Benjamin. We need to tweak the language so that it is not just prospective, but that we are looking in the rearview mirror too. So I think we're going to have to do a rewrite on that. That's my first opinion. The second point is, and Senator Marston just confirmed a concern that I had that just popped up, and that is when Senator Stanley was asking about the juvenile domestic relations convictions, that is considered a status violation, which may very well jeopardize some federal funds. And so I think we're going to have to tweak that portion of it as well, so that we are not inadvertently avoiding a criminal situation, but creating a status offense for a juvenile individual. So I think we're going to have to rework that a little bit as well.
Mr. Chairman.
Senator Serval, go ahead.
Can I finish on the expungement thought really quick?
Go ahead.
And just Senator Norman and Senator Zebin, I also just want to confirm, though, that it's your all's intent that if somebody's charged with a civil infraction of marijuana possession in the future, and the charge is null prost, found not guilty, otherwise dismissed without a finding of guilt, because they weren't guilty or they couldn't prove it, that you all want that civil infraction to also be expungible like a criminal infraction would be today, because right now you can't expunge a civil infraction that's dropped or dismissed.
Senator
Okay,
Morrissey.
so
Senator
everybody,
Morrissey.
council has that, okay.
Thank you, Mr. Chairman.
The short answer is yes.
Okay.
Right.
Which the executive director of the Supreme Court, as you know, has promulgated a fairly simple form on expungement. The form is not the issue. The issue is the position of the Commonwealth Attorney. So we may have to end up tweaking that form a little bit as well.
Senator Morrissey.
Mr. Chairman, so summarizing, what we've all agreed, I think, is that the expungement portion of this legislation needs to be tweaked. I also think that we've agreed that another portion that needs to be tweaked is that we are making it a civil penalty for adults and a criminal penalty for juveniles, and it's usually the other way around. The juveniles are the one that get the benefit or mercy. That needs to be tweaked.
Is there a motion
We're in
we pass
agreement.
it by for the day?
And the third one that I want to bring up, Mr. Chairman, so that it can be tweaked if necessary, is this. This is still an unlawful offense, correct?
Right, a civil offense.
No, it's a,
It's a civil offense where you get a ticket. That's not within the law.
look at line 70, look at line 492. It is unlawful for any person knowingly or intentionally. Now, do you see that?
Yes.
All right, so let's be clear that this legislation right now says that this is still a crime, albeit a civil penalty. And I want to bring this to the committee's attention, and I think our staff attorney may want to weigh in as well. This would allow the police to stop a car, and the police officer says, I smell marijuana in there, allow that person to do, as they now do, a full-blown search of the car because there's unlawful activity committed in their presence. And that, Senator, is the real problem with this marijuana. It allows for the police to stop automobiles, and this is what's going on. They'll stop a car, 10 cars are stopped, and 9 of them don't have any marijuana in it. They've searched the car, they go about their business. The 10th car they search, they find marijuana, and when the case comes up to court, the judge says, he must have had a pretty good nose because he found marijuana or some other drug in the car, not realizing that 9 of other 10 car people were also stopped, had their car searched, and went about their business. So I am concerned about that language being unlawful. And the last thing is this. The genesis of this bill was to help people who were looking for a job, housing, or schooling, and they were being penalized because of this. I remember Senator Norman reading a year ago about your comment in the press about this, and I thought it was spot on, as the Irish would say. We're still doing the same thing, even though you call it a civil penalty. It still's on their record. That still affects jobs. It still affects housing. It still affects schooling, and I think that needs to be tweaked too.
I'm fine to get the feedback of the committee so we could come back next
Yeah,
week. but-
we've not yet adopted the substitute. What I'd
Okay.
like to do is send this to the criminal law subcommittee and then come back, okay? So we
That
can
would be
fix all
great.
these problems. Okay, we'll give you notice when the bill comes back up, okay?
Happy to do that.
Now,
Okay.
Senator Eben, you have another bill?
I do, and this is one that you had as well, sir. I don't know if you want to, if
I'd
we
like
should
to-
roll this in or how we want to
Yeah,
handle it.
this would be Senate Bill, let's see, 17, same-sex marriages, civil unions, to
Yes.
abolish the statute, and I have the Code Commission's identical bill, Senate Bill 39, same-sex marriages, civil unions. It's a Code Commission bill.
Yeah, I have not looked at yours, but I believe that we have the exact same wording
Yeah.
from when I brought the bill to the Code Commission several years ago.
Yeah, would you like to move that my bill, Senate Bill 39, be rolled into your bill?
I can't move it.
Yeah, I
but-
make that motion. Is there a second? Is there a second? Senator Deeds votes second. I move second. All in favor of the motion that my Senate Bill 39 be rolled into Senator Eben's Bill 17, and the two chief patrons should be, the two patrons be chief patrons on the bill. All in favor of the motion to roll them in, vote aye. All opposed, no. The clerk will close the roll.
Ayes 14, no zero.
Motion carries 14-0. Okay, Senator Evan.
Yeah, thank you, Mr. Chairman. I think this is a pretty straightforward bill without making it a big, as big a social issue as it used to be. It's been more than 5 years in Virginia since same-sex marriage has been recognized by the courts and has been the law of the land. Now, and it was reaffirmed by the U.S. Supreme Court in Obergefell versus Hodges in 2015. We don't expect anything to change. The Code of Virginia has to it should accurately reflect the law. We need to remove any legal ambiguity and confusion. This was the unanimous recommendation of the Code Commission on May 7th, 2018, with Senator Edwards, Senator McDougal, Delegate Habib, then Delegate Habib, and Delegate Leftwich at that time. And then we brought it here, and it didn't pass. So again, I think the code needs to accurately reflect the law. I'm not trying to make a big statement other than to give people dignity who are already allowed to be married.
The Supreme Court has acted on this. The Code Commission has recommended the bill on the grounds it's obsolete. We want to get rid of obsolete laws in the Code of Virginia. I move that the bill is rolled into Senate Bill 17 be reported. Is second. All in favor of the motion, vote aye. All opposed, no. Motion carries by a vote of John.
Ayes 9, nays 5.
The bill is reported by a vote of
Thank you, Mr. Chairman.
9-5.
Thank you. I look forward to seeing the members of the subcommittee on the other bill.
Thank you.
Thanks.
9 to, what was it, 3? 9-5, okay. Okay, now, Senator DiStef, sorry to keep you waiting, and sorry that you had to wait on Monday as well. But I understand you have some law enforcement officials here. Which bill would you like to take up?
Mr. Chairman, members of the committee, I'd like to first start by taking up Senate Bill 42, sexual battery by false representation or subterfuge.
Okay.
Give you a
Senate Bill
quick-
42, give your attention to Senator DiStef.
Thank you, Mr. Chairman. It provides that any person who sexually abuses another through false representation and subterfuge as part of a massage or massage therapist, medical procedure, physical therapy is guilty of aggravated sexual battery. Such abuse is intentional without explicit consent of the complaining witness. Bill also admitted, let's see, I think that's all this one does. And I'm going to give you a quick example. This passed this, I'm sorry, we have a substitute.
Okay. Got a substitute. Is a motion to adopt the substitute? Second, moved and second. All in favor, say aye. Aye. Okay. Substitutes before us.
So, Mr. Chairman, members of the committee, this basically came about because things like the Groupon type massages, when people would advertise that they're masseuses, and then they would take advantage of the individuals once they got them in, and it kind of went downhill from there. But I'd like to get our special victims unit folks to kind of give some examples and talk about this a little more. This went in front of you last year, was tweaked a little bit, back and forth a few times, went in front of finance, and we did not find the $50,000 for the Woodruff Amendment. But with that, I'm going to turn it over to my subject matter experts, if that's okay, Mr. Chairman.
Okay, be great. Okay, who wants to speak?
Mr. Chairman,
Hey, Chris.
members of the committee, Chris Rehak, I'm the Commonwealth's attorney in Radford. And I've been doing this kind of work for about 20 years. And just in the last 4 years, I have had 2 horrific cases where this law would have been a tremendous help. In the first case, we had somebody who was a licensed massage therapist in town who preyed on our college students, mostly female college students, and he would get them into his massage studio and would touch them inappropriately. And I had 7 victims altogether who were mortified they were paralyzed in fear as this is kind of going on. One of my victims had never had a massage before. She thought this was normal. One of my victims had a mental disability, and it was that only, her case was the only felony I was able to prosecute in this case. All I was left with was a bunch of misdemeanor sexual batteries. The second case has just happened in the last year or so, and it's pending, so I must be careful. But I have somebody who advertised their services as having a degree that's called a PSCD degree, a practicing pastoral medicine or Bible-based health care. And there is a Texas agency called the Pastoral Medicine Association that will give you a license in all 50 states to be a therapist. So this gentleman who converted his garage, listen to this, he used his church connections and his Bible-based healthcare plan to turn his garage into a pseudo doctor's office and proceeded to create 33 separate victims who saw him for procedures that go as far as lymph node drainage, anal exams, and cervical exams, sometimes without gloves. He found women who were cancer survivors and claimed he could cure their cancer by checking their private regions. He would buy white lab coats and scrubs online and look like a doctor. Now, he never said he was a doctor, but everybody, these women that went to see him, and some men even went to see him, were all touched inappropriately. Some of them consented, some of them didn't. Most of them, well, none of them were hurt in the way that the statute right now requires an injury, as you know. So this statute, this law change, will capture an entire class of victims who right now are not covered by a felony statute. Thank you.
Okay, any questions? Any questions? Yeah. Yeah, Senator
Chris.
Peterson.
Yes.
Yeah, I got a question for Mr. Commonwealth's attorney.
Yes.
That all makes sense to me. Do we need to say during an alleged massage, medical exam, or physical therapist? If I was defending, I might say, well, it wasn't a real medical exam, so.
Well, so one of the things I wanted to mention was, of course, I would be remiss if I didn't say the words Larry Nassar. Everybody's familiar with Larry Nassar.
Right.
Okay. Some of these people could be doctors and violate this.
Right.
Some people pretend to be doctors and could violate this.
Right.
So we want this to cover trainers, coaches, and the
Okay.
massage people.
All right, so I guess my further question, Mr. Chair?
Yeah, Senator Peterson.
And I understand the Larry Nassar situation. I guess my question is, shouldn't it be actual or alleged? And the reason why I say that is, if they're not an actual doctor or they're not an actual massage therapist, and they say, well, look, I was playing, I just lied, you know? It was just, I lied. And that's not, in other words, do we need to say actual or alleged? I mean,
What line are you
Perhaps,
talking about?
but
What
we-
line
we-
are you talking about?
We
Exactly.
want the massage therapists who have certificates but do inappropriate massages covered. But you're right, we also want people who have falsely put themselves out there.
Right.
As being licensed to do any of this work.
so I think this is a friendly amendment. If we add the word after during an actual or, I was going to say, during an actual or alleged massage medical exam, do you understand what I'm trying to say?
Mr. Chairman,
Yeah, Senator Obenchain.
and I think we all understand what he's trying to say. Maybe council can come up with something. I don't know whether we can.
Putative? I don't know.
I'm not sure alleged is the right word.
Putative? I don't know.
I like-
Counsel.
Help me.
Let's
I
have
like-
here, counsel.
I liked a portion of the original bill, and my concern about the substitute, one of my concerns is that, as it reads, it's simply part of a massage, which would unintentionally, because I know the patron doesn't intend this, reach couples, intimate partners. I mean, anybody who gives a massage to somebody that becomes intimate would have to get express consent, and I know that's not intended. But the original bill spoke of a massage therapist as defined in the code, and you might want to add to that, or person purporting to be a massage therapist, so the category is narrowed to those people who are actual massage therapists are holding themselves out to be. And the original bill said that is part of a massage because we know that this kind of inappropriate touching is not part of a legitimate massage. We changed the wording to during. And so using the substitute, what we might want to do is change the language so it reads, and this is on line 23, subdivision 2, during a massage by a massage therapist or person purporting to be a massage therapist as defined in the code section.
Are we okay with that, or, yeah?
I'm going to need a copy of the substitute, if I could. These and yeah, we.
My other concern is whether the statute as written reaches that person who is a licensed massage therapist, but who extends the massage into inappropriate areas without saying anything. And my question would be whether that would be a sufficient misrepresentation, because it's just implied that this is
I think that's where we covered, Mr. Chairman and Ms. Benjamin, under express consent of the complaining witness. That's where we threw in express consent on line 25. So they would have to ask for that consent and then receive it back.
But the statute, Mr. Chairman, also requires that there be a false representation or substitute. And it can be argued that if you're giving a massage and then you go to an intimate area, that is impliedly misrepresenting that that's appropriate. But I feel like it should be stronger. So
Yeah.
If I may explain where that wording comes from, I'm Amanda Condon. I'm a police officer with the Virginia Beach Police Department. I've been working with Special Victims Unit for 3.5 years. Just as the Commonwealth Attorney explained, we often come into contact with victims of massage, holistic doctor, physical therapy, stuff like that, where the only way that we can charge for a felony level assault vaginal penetration is under the misdemeanor sexual battery code, where it covers force, threat, intimidation, or ruse. So we've been charging under the ruse element for people who are trusted professionals, and that is where this is coming into play with these victims. That might explain, the verbiage of the subterfuge is the ruse, and that's kind of just the catch-all that we've been able to use in these charges rather than charging the felony. So the sexual battery code just covers sexual abuse, but it requires force, threat, intimidation, or ruse. So ruse is just something that, and I think the Commonwealth Attorney can probably speak better on that. We've used ruse for people who are using their professional standing to get these people in these positions. So I don't know legally where it goes between being a fake doctor, a real doctor. I specifically worked a case where there was a Groupon with a massage therapist who ultimately was not a legal massage therapist here. Right. Right. Okay.
To any amendments?
Mr. Chairman, I want to make sure we get this right. And Senator Peterson is correct that there are two separate crimes here that we're trying to embrace by the entire thing. I'd like an opportunity to work with the patron a little bit more to make sure that we have it nailed down, and I'm willing to do that.
Shall we go by for the day or send it to the subcommittee?
Subcommittee.
There's a criminal law subcommittee.
It doesn't matter.
All right, we'll go to Senator Deeds' criminal law subcommittee and report back as soon as possible. Okay, thank you. Does anybody else want to speak before we leave, though, so they give an opportunity to speak, so you wouldn't have to come back?
Good afternoon. My name is Sergeant Ryan Jason with the Virginia Beach Police Department. I appreciate you guys' time. I know it's very short, but supervising the Special Victims Unit is part of the reason why I'm here. When we got into the situation with that case, we didn't want to see the victim fall between the cracks of the state code, and that's one of the reasons why we were coming forward to it. So I don't have anything really in addition to what Amanda had said. I appreciate your time.
Good.
Thank
All
you.
right. Anybody else would like to speak? Okay. All right. We'll send it to the criminal law subcommittee. I've been advised by Senator Oberstein there were people here who would like to speak on the marriage amendment and didn't get a chance to speak. I'm going to move to reconsider the vote by which we passed Senate Bill, was it 17? All right. And all in favor of the motion, reconsider the vote by which we reported Senate Bill 17. All in favor of that, say, vote aye. All opposed, no. Good. All right, the motion is, clerk will call the roll, report the roll.
14-0.
Okay. The bill has been reconsidered. Are there people here who would like to speak on the marriage amendment? Senator Evans, Senate Bill 17. I want to give you the opportunity to speak.
Mr. Chairman?
Yeah.
Mr. Chairman?
Yes, Senator Oberstein.
And I apologize. I know that those two bills, was it one or two?
There were two, yeah. They're rolled
Right.
in together.
I wasn't sure whether, I know that as we were trying to roll through these bills, at least on the marriage bill, that there were people here who wanted to speak, and I didn't even notice that they were there, and I know that the chair didn't intentionally deprive them of the opportunity to say anything, but I don't know what, and Senator Eben told me that he thought maybe same thing happened with the marijuana bill.
I just misunderstood you. When you told me that, I thought I should bring them back, but the marijuana one's going to subcommittee, so I don't think we need to do the same thing.
Okay.
Yeah, that's fine.
Marijuana's in subcommittee. Okay. Okay, now, those against the marriage amendment bill. Okay, thank you.
Thank you, Mr. Chairman. Josh Hetzler with the Family Foundation. I appreciate the opportunity. I don't mean to waste your all's time, but I do think the institution of marriage is so important, as I know you all do. I thought it deserved a word. And the Family Foundation exists because we know that strong families are the foundation for every free and prosperous society. And marriage is the cornerstone of that foundation. And we know that marriage is an institution established not ultimately by government, but by God himself as a complementary union of male and female, and therefore that no person, and in fact no government, has any authority to change it, but that all are obliged to recognize it. We know that marriage is an objective good for the health and well-being of individuals, society, but especially children, and that societies rise and fall on the degree to which they respect this sacred institution. We know that married biological parents embody the optimal environment for children who thrive best when they have both their mom and their dad. Not very long ago, these truths were universally recognized. Just consider that the top 4 ranking members of this very committee, Chairman Edwards, Senator Saslaw, Senator Norment, and Senator Lucas, all voted for at least one of these laws that the bill now seeks to repeal. And I would just add that in having the opportunity to observe each of you, I don't believe for a moment that that vote was motivated out of bigotry or intolerance, but that it was because you understood that there was value in marriage and what it meant. And
Yeah, Senator Seslaw.
You might be referring to back in 1998, and just to update people, I remember when President Obama ran for office initially he was opposed to it. My vote was not because of what you just said. My vote was that I think it was Senator Newman that had it, was out of pure ignorance, okay, and nothing else. And, you know, the more and more I learned about it, the more and more I saw how wrong I was. So, you know, don't tell me what my vote was. My vote was out of stupidity, okay?
Okay, go ahead.
Thank you. I will just end with this. So some may say that times have changed, but I'm here to tell you that the nature of marriage and of male and female never have and they never will. And though I know I don't expect you to change your vote, I would still urge you to have the Code of Virginia reflect that. Thank you.
Thank you. Okay, next. Appreciate you coming.
Mr. Chairman and members, Tom Antorcio with the Virginia Catholic Conference. Marriage between a man and a woman is the human and social institution upon which the civilized world has been structured since the very beginning, across times, places, and cultures. Marriage has an original design and purpose that predates any nation, religion, or law. A core duty of government is to preserve this institution and pass it on to future generations. In light of the current federal law, it is true that the provisions in the Virginia Code that marriage is exclusively the union of a man and a woman is not in effect at this point. Right now, it is a dormant provision. It is also true that Supreme Courts change and federal laws change. So a state law that is dormant now would become effective again if the federal law changes, but only if the state law remains on the books. The decision before you today, therefore, should be based on what you believe is the right policy for Virginia. If you believe, as we do, that marriage is and can only ever be the union of one man and one woman, please vote to continue reflecting that in our state code. Thank you.
Okay, next.
Eddie Ayla, Virginia Assembly of Independent Baptists. We identify with the comments that have been made and realize that government can do what government thinks is best, and the church can do what it thinks is best. But we, of course, hold to the view of marriage as was stated. Thank you.
Okay, thank you. Senator Morrissey, Senator Morrissey, did you? Yeah.
Thank you, Mr. Chairman. First of all, thank all three gentlemen for speaking, and I know that comes from your heart. Josh, I think my wife and I had dinner with you and your wife and another couple, and wonderful time, and we respect your opinions, but I also respectfully disagree with your comment that societies rise and fall on the basis of a marriage between a man and a woman. And I would ask any three individuals, is there any empirical evidence that the family unit, much less society, is downgraded or somehow it's detrimental to have a marriage between two people of the same sex? Any empirical evidence at all?
Mr. Chairman, Senator Morrissey, thank you for that question. I would say there's many, many decades of empirical data, sociological data. I would be happy to provide it for you. Somehow I think that would not make the difference for anyone here. But yes, there is, and I would be happy to provide that for you.
Thank you,
Senator Saslaw?
Yeah, I would just say this, that what you all heard earlier from the young gentleman there, I heard almost the exact same words back in the 50s and 60s in this state concerning interracial marriages, okay? Exact same words. And it was wrong then, it's wrong now. I honestly believe that. And I remember when, I think it may have either been Cuccinelli or Bob Marshall had that bill in the early part of the last of 2 decades ago. Somebody got up on the floor of the Senate and remarked that, you know, this was going to do permanent damage to the if we didn't pass this, that marriages between two people of the same sex would do irreparable damage to the institution of marriage. And I remember I got up and I asked that person, I said, kindly tell me how two people of the same sex getting married affects my marriage to my wife, Eleanor. And nobody could get up and give me an answer. And the bill that what Senator Eben has put in is something that was long needed and long overdue. And I'd move that we report it.
Okay, it's been moved and.
Mr. Chairman.
Yeah, Senator Overchain.
You know, and I have great respect for Senator Saslaw and for the people on the other side. You know, this debate over this issue has gone on for a long time. I think well-meaning people are on both sides of this debate. I just regret, I would regret it if we get to a point in our civil discourse and our discourse in this or other committees in which we are berating or discouraging citizens from coming to address us with heartfelt, faith-based beliefs. I do not question the sincerity of the members and members of the gallery who have views that are different from mine on this issue or any other. And I just, and I appreciate their willingness to come out and express those views, even in past years when they knew that it was perhaps not going to prevail for the day. I hope that the Family Foundation, the Catholic Conference, the Baptists will continue to be welcome in this committee, and that we won't discourage them from coming and expressing those views. I think we're better for allowing them to do so, and I just would hope that we're not going to go down that path and discourage people from expressing those views just because we disagree with them.
Mr. Chairman?
Okay, Senator Eben.
Very briefly, I just wanted to just close with a thought or two. The witnesses said that biological parents in a family are very strong and the best kind of family. I just want to point out that adoptive parents, whether straight or gay, are doing a great service to the community and matter quite a lot, and that one kind of parent is not superior to another. I'd rather see a kid in a loving home than in an orphanage or foster home have some permanence. Also, my intro was just code should reflect the law, but I also wanted to say in terms of religion, we have freedom of religion in this country, and if my religion says that we recognize a marriage and another says we don't, that's fine. You don't get married in your particular church, but the law is the law. And I'll just close with it. And further, this removal from the code does not make gay marriage in the affirmative in the Code of Virginia. It merely removes the prohibition and lets federal law apply. And lastly, I'm just going to quote Thomas Jefferson. Senator McClellan's tired of this, but I've said it a few times, and she can quote it back. Jefferson said, "I'm not an advocate for frequent changes in laws and constitutions, but laws and institutions must go hand in hand with the progress of the human mind. As that becomes more developed, more enlightened, as new discoveries are made, new truths discovered, and manners and opinions change, with the change of circumstances, institutions must advance also to keep pace with the times." So I'm just suggesting human minds become more enlightened as the U.S. Federal law has. Okay. So with that, I'll just ask you to consider.
All right. Anybody else want to? Thank you very much. Anybody else want to speak? It's been moved and seconded that the substitute be reported. All in favor of the motion, Senator Saslaw? Vote aye. All opposed, no. The vote is open. Okay, the clerk will close the roll. Ayes 9, noes 3. The substitute is reported. And, substitute is reported. All right, thank you. Okay, Senator DeStef, sorry for the interruption.
Mr. Chairman, members of the committee, that's perfectly fine. Next bill we'll take up if it's okay, is Senate Bill 169, warrant issuance. And this one was basically magistrate shopping. It passed this committee last year. It passed the House, passed the full Senate, went on to the governor, was vetoed. But I'd like to walk through this one a little bit. It provides that magistrates may not issue an arrest warrant for a misdemeanor offense where the accused is a law enforcement officer and has the alleged offense arise out of the performance of his public duties upon the basis of a complaint by a person other than a law enforcement officer or an animal control officer without prior authorization of the attorney of the Commonwealth or by law enforcement agency. The bill provides that the appointment of an attorney for the Commonwealth from outside of the jurisdiction and a conflict of interest exists for the attorney for the Commonwealth having jurisdiction. And Mr. Chairman, members of the committee, this was about a year and a half, almost 2 years ago, that the incident happened where an officer initiated a stop. The car fled, striking several vehicles. The suspect fled on foot with the officer in foot pursuit. The officer caught up to the suspect. They fell to the ground and a struggle ensued. The suspect resisted to comply to the officer, become assaultive. The officer punched him once or twice. In Virginia Beach, if an officer punches a suspect, closed fist punch to the head is against department policy. Well, the suspect was actually on his stomach and elbowing the sharpness of the elbow, and we all know the sharpness of the elbow is more strong and more lethal than closed fist, and struck the officer multiple times with the elbow. The officer punched him in the head. Charges were screened with a Commonwealth attorney who refused to prosecute. Then the suspect went to multiple magistrates until he found one that would issue a warrant, which happened in the middle of the day, taking the officer off of his job for the next couple of days while he had to go through this process. Again, this was looked at by the department. It was looked at by the Commonwealth attorney. They went through everything on this and refused to prosecute. The suspect was later convicted on federal drug charges and then sentenced to federal jail. But this bill passed out of here last year, passed the floor, passed the House, and I think it's a great bill, and it stops something that's currently affecting our law enforcement officers.
Okay, any questions? I have a question.
Chairman.
I thought in order for the magistrate to issue an arrest warrant for a misdemeanor violation, the person who goes before the magistrate has to have seen it himself, has been physically present and saw what happened. Is that right, Steve?
What was the first part of that?
In order to arrest, for an officer to arrest a person on a misdemeanor charge.
Yes, he must have observed it. That's
Must have
correct.
observed it himself.
Right.
How do you get around that in this situation?
You don't get around that.
No.
I'm not certain.
In
of
other
your
words,
question.
like a citizen says, I want to charge this officer with assaulting me.
Well,
How does it work
in
today?
in the scenario, Mr. Chairman, the citizen did observe
Did observe
what
it.
took place, was saying that he was a victim, actually. He was
So
the suspect.
how would you then get an arrest warrant from by an officer or a Commonwealth attorney?
Well, you don't get it from another officer or Commonwealth attorney.
Yeah.
They approve the issuance
Okay,
of the
all
warrant.
right, that's all it is, just
That's all it
approving
is,
it.
sir.
Okay.
That's
So
correct.
the citizen would have to go to a Commonwealth attorney?
Yes, or another law enforcement officer.
So it could be a police officer, any police officer could then go to the magistrate and send, I have a witness here who saw it.
Right.
Okay.
That's right. And Mr. Chairman, I mean no harm to the bill whatsoever, but it is my role to point out when bills like this come to the committee that this is one of those, whenever we create a category of citizens who enjoy a greater protection, that leads to what the committee characterizes as a Christmas tree effect. In passing this, understand that additional, probably equally deserving professionals, emergency rescue personnel, firefighters, for example, teachers will be wanting and arguably deserving the same protection. And that's just the note that I have to make for the committee whenever we have something like this. An additional thought, and it's been contemplated before in years ago, was removing the right of a citizen to, on his own initiative, swear out a criminal warrant. And that's your alternative. If the committee does not have a taste for creating a particular protection for one category of citizens, in this case, law enforcement officers, then another approach would be to require that a prosecutor or a law enforcement officer approve a warrant that is sought by a citizen. And I just throw that out so that the committee has those options to consider, and that's it. I mean no harm to the bill.
Yeah, Senator Morrissey.
Thank you, Mr. Chairman. First of all, I agree with staff attorney when he says we're going down a very dangerous slope if we want to carve out a group of people who are protected. That's the first thing. The second thing, Senator, is that this situation that occurred is not unusual. A layperson trying to get an assault warrant against somebody, another layperson who assaulted him, often might not get it from the first magistrate or the second or the third, but normally a good magistrate, a good neutral and detached magistrate will ask the following question. Have you ever tried to get this warrant before? And when the person says yes, that sends up a red flag. But I agree. There's two problems with this legislation. Number one, carving out an exception for a protected group, and then also trying to correct it by saying without prior authorization of the Commonwealth Attorney. Let me ask you this. How do you think that's going to go? The police officer that deals with that CA all the time says, listen, I want you to either issue this warrant or not issue the warrant. Again, it doesn't protect that the individual, somebody who actually may have been a victim. So it's those two reasons that I think that the legislation is flawed, notwithstanding that egregious case that you talked about.
In response, I'll say this, the governor vetoed it last year and wrote, this bill would prevent citizens from holding law enforcement officers accountable and unnecessarily limits the authority of our magistrates. That's what the governor said.
Understood.
Yeah, for what it's worth. All right, any questions? Is there any motion?
I'll move to report.
Been moved and seconded to report the bill. Substitute motion. Is there a second? It's been moved and seconded to PBI the bill as a substitute motion. All in favor of the motion to PBI the bill, vote aye. All opposed, no. Clerk.
Ayes 9, noes 5.
All right, ayes 9, noes 5. Thank you.
Mr. Chairman, members of the committee, thank you very much. Now I'll direct your attention to Senate Bill 90, capital murder punishment.
Okay.
Mr. Chairman, members of the committee, this was brought after the mass shooting in Virginia Beach. It provides that any person convicted of capital murder involving the willful, deliberate, or premeditated killing of more than one person as part of the same act or transaction, or more than one person within a 3-year period and who was 18 years old or older at the time of the offense shall be sentenced to no less than mandatory minimum term of confinement for life.
Okay.
Pretty clear. It says if you've shot multiple people, willfully planned it, et cetera, that you should be convicted for life.
Is this
Confined
already,
for life.
is this already a crime? It's already a crime. Multiple murder, yeah. It's already capital murder, isn't it?
It is, but if I can direct your attention to line 55 of the bill, it adds number 7 and 8, which is the willful, deliberate, and premeditated killing of more than one person, and it makes it mandatory minimum term of confinement for life.
But the only difference is that you're adding mandatory minimum.
That's correct.
Okay. But it's already a crime.
Mr. Chairman.
Yeah.
Yeah, it's already a crime.
Already capital murder.
Yeah, it's already a crime. But what this does is makes it a mandatory minimum sentence of confinement for life. In cases of
number 7 and 8 under the code, willful, deliberate, and premeditated killing of more than one person or more than one person in a 3-year period.
Yeah, I remember, I've worked on that bill, as a matter of fact, passing in 1996, as I recall. Okay, any questions of the patron? Is there anybody would like to speak for or against the bill? Yeah.
Bill, the existing law is that if somebody is convicted of capital murder, the choices are death or life, but the life portion, that's the jury's option. You got death or life, but the judge can suspend a portion of that life. You agree?
Correct.
Okay. So what this bill does is takes away the discretion of the judge if he feels circumstances warrant suspending part of that life sentence.
That's correct. And what this does, it says if you killed multiple people, premeditated, it's mandatory life imprisonment. So there's no, we'll give you time off for good behavior. There's no, well, you know, you only killed 3 instead of 30. There's none of that. This says mandatory life in prison, period.
Mr. Chairman.
Yeah, Senator Morrissey.
Let me give you the following scenario. 2 people go to a crowd, and one of the individuals drives the other, not knowing that he may be up to mischief, but not knowing exactly what he's going to do, and that other individual commits this multiple homicide, all right? The second person, because he was a principal, all right, in the second degree, didn't commit it, but was there, aided, i.e. drove the person there, is convicted of capital murder. Do you not think that that person who was a principal in the second degree did not pull the trigger but was convicted of capital murder, and the jury only had 2 choices, that in some circumstances, particularly that one, the judge would be warranted in giving that person less than life, perhaps 50 or 40 or 30 years?
Mr. Chairman, Senator Morrissey, if I may direct your attention to lines 7 and 8, where it says willful, deliberate, and premeditated. So that individual did not have it as premeditated. It may have not been willful or deliberate in his case, so he wouldn't fall under this, that second person. Now, the first person, willful, deliberate, and premeditated. Those are the 3 terms here. It has to be willful, deliberate, and premeditated.
Mr. Chairman.
Yes, Senator Morrissey.
And Mr. Benjamin, you can correct me if I'm wrong, but however, that principal in the second degree doesn't have to commit the willful, deliberate, and premeditated murder. If he is charged as a principal in the second degree, he can be found guilty just as if he committed the crime himself, and the willfulness, deliberateness, and premeditation is attributed to him through the actions of the first party.
Mr. Chairman, Senator Morrissey, Senator
yeah.
Steph, that's correct. Yeah, under that or the theory of acting in concert. If somebody aids and abets, they're a principal in second degree. And under Virginia law, you can be deemed to have aided and abetted if you are aware of what's going on and simply remain silent, because your silence while you're there and present with somebody who you arrived with can be considered encouragement. And so the concern, I think, that, Mr. Chairman, that Senator Morrissey is expressing is that category of folks might be swept up into this mandatory life sentence who even the patron might think don't necessarily deserve a mandatory life sentence. I don't, and as I sit here, I can't offer a solution to that, but that is a concern that is being expressed.
Okay, any responses? Okay, the Common Attorneys.
Mr. Chairman.
Phone a friend.
Title 18.2-18, which is considered the triggerman rule, under the particular provisions of that this bill is addressing, states that an accessory before the fact or a principal in the second degree to a capital murder shall be indicted, tried, convicted, and punished as though the offense were murder in the first degree.
That's correct.
So it would take it out of the capital
That's
offense.
correct. We've got that in front of us now.
Yeah, okay.
Mr. Chairman, again, there's a lot of brilliant minds here. I'm not one of them when it comes to this stuff.
Yeah.
So I'm happy to phone a friend for answers.
Who else would like to speak for the bill? Who else would like to speak against the bill? All right, is there any discussion? Is there a motion? Been moved and seconded to PBI the bill. All in favor of the motion, vote aye. All opposed, vote no. Okay. The clerk will close the roll.
Ayes 9, noes 5.
Okay, thank you, Senator DeSteph. The vote is to pass the bill by indefinitely on a vote of 9-5. Okay?
Mr. Chairman, thank you very much. And then on Senate Bill 483, the witness we had for this, or the witnesses we had for this were here on Monday, but they're not here today. So we had a request if we could pass that by for the day.
Okay. There are a couple of bills to be passed by for the day, too. Do you have any other bills?
That's it, Mr.
Okay,
Chairman.
all right, thank you very much. And again, I apologize for that on Monday. I understand at the request of Senator Stewart, we would pass by for the day Senate Bill 148 and 154. Senate Bill 148, 154, Senator Stewart's bills. They will be passed by for the date at his request. Okay? Now, where are we? Who's next? Yeah. Senator Frivola? Who's here? Oh, Senator Marston, okay. Senator Marston, Senate Bill 242,
Could we do 103
okay.
first?
103. Senate Bill 103. Pay attention to Senator Marston.
Thank you, Mr. Chairman. This legislation seeks to align Virginia code with Supreme Court decisions regarding the sentencing of juveniles. The United States Supreme Court in multiple cases has ruled that juveniles must be treated differently from adults when it comes to being sentenced to life without parole. We basically have three decisions. Graham versus Florida dealt with non-homicide cases that says that juveniles must have a meaningful, realistic opportunity at release. In Miller versus Alabama, it was about, at the time of sentencing, making sure that one considered the possibility of rehabilitation and mitigating circumstances at the time of the commission of the offense, and said that these cases would probably need to have a rehearing. And then ultimately, Montgomery versus Louisiana, which essentially said that Miller was retroactive and that the best way to deal with all of this stuff is with a parole option for these kids. So since if you did it for kids who have life without parole, and you give them a 20-year option, you would also have to give that same option to any child who was sentenced as an adult. You would have to give the same option to anybody serving more than that 20 years for any one felony or series of felonies to be fair, because those were actually lesser offenses than the life without parole. So basically what it does is create this parole option for a juvenile sentenced to prison who has actually served more than 20 years of incarceration, that they would be eligible for a parole hearing, and that's just eligible. It has nothing to do with any kind of automatic release, and essentially that is what the bill does.
Okay, anybody would like to speak in favor of the bill?
Mr. Chairman, members of the committee, James Dold representing the Campaign for the Fair Sentencing of Youth based out of Washington, D.C. We're here to speak in support of the bill, and we thought we'd provide just a little bit of context nationally for where other states around the country are at in light of the Supreme Court decisions that Senator Marsden previously referenced. Since these decisions came down, we've seen the number of states that have banned the use of life without parole sentences for children quadruple, including in neighboring West Virginia and the District of Columbia. But really, these reforms have sort of taken hold all over the country, including in Texas and Arkansas, which both also banned life without parole sentences for kids and retroactively gave children parole eligibility, as well as in more liberal states like Vermont and Massachusetts. I always tell people, when you get Texas and Arkansas on the same page as Massachusetts and Vermont, you're onto something that's truly bipartisan, and you've bridged the bipartisan gap there. Since these decisions have come down and these legislative reforms have gone into effect, I'll also note over 500 people have been released from prison in these states with a 0% recidivism rate, and these were all children who were convicted of first-degree or capital murder. So what it says is that the system that these other states like Arkansas and West Virginia have enacted that give parole eligibility to these children is working. Of course, we're not saying that everyone should be released from prison. That's not the goal of this legislation. It's simply to give those people who've demonstrated their maturity and their fitness to reenter society a second chance at life. I'd also like to say, in every other area of our society, we treat children differently. We don't let children vote. They can't serve in the military. They can't enter into contracts, and they can't get married. The one area where we
Can't
don't
drink beer either, right?
That's right. The one area where we don't treat children differently is in our criminal justice system. And so this bill is really about mercy, redemption, and second chances. And in closing, I'll just note, I often do this because we work across the political spectrum with folks as conservative as Newt Gingrich, as well as liberal as probably the most liberal person you can think of. And one of the things that I'm reminded of is an op-ed that former Speaker of the House, Newt Gingrich, penned a couple of years ago. And he wrote, Jesus told us to do unto others as we would have done unto us. If these were our children or grandchildren, what would we want done in these situations? And so we would simply say that if our children are not deserving of our mercy, then who amongst us is? We ask for a favorable support for this bill. Thank you.
Isn't it true that children are also more impressionable, more willing to follow others, and are not and are rehabilitatable too? They're still growing and still maturing, right?
That is correct, Mr. Chairman. So the underlying rationale of the Supreme Court decisions really was based on the proportionality analysis. And what the court said was that all the things that you just mentioned, how kids are different, their brains aren't fully developed, also lead them to being more impetuous, more prone to irrational decision-making, more susceptible to peer pressure. It also means that they are more likely to be rehabilitated over time than an adult who commits the same sort of offense. And so the penological justifications for imposing the harshest possible punishments begin to fall away when we consider the mitigating characteristics of youth. And that is also the underlying rationale for a lot of the other states and surrounding countries, surrounding states around the country that have enacted this reform. Also just point out that Virginia is one of only 6 jurisdictions in the entire country that has not begun the resentencing process for children or enacted reforms to make sure that they're in line with these Supreme Court decisions. So we would hope Virginia would pass these reforms to be just as progressive as Arkansas.
And isn't it true, too, that the judgment faculty in the brain, which we studied, is right up here in the subfrontal lobe somewhere, and that doesn't mature to 24 or 25 years old, right?
That is correct. That's the prefrontal cortex, and what it shows is that children actually rely a lot more on their amygdala, a more primitive part of the brain, when they're making decisions, which is why they make such irrational decisions. I'm sure anybody on the committee with a teenager can attest this, all of them, or think back to when you were a teenager, all of the very stupid things that we all did. We actually have an op-ed that's I will speak for myself. I did a lot of dumb things as a teenager. So we hope that this bill will provide the second chances that children here in Virginia are deserving, just like the children in West Virginia, the children in Arkansas have received as well.
Okay, thank you very much.
Thank you.
Anybody else in favor of this bill? Commonwealth attorneys.
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys, and we come at this bill from a slightly different aspect than has been previously spoken about. There's a couple of other cases as well that have not been mentioned. One dealing with this particular issue as far as the Virginia Supreme Court is concerned, and I'm not sure if it's pronounced Angel versus Commonwealth or Angel versus Commonwealth, but it is a case in which the Virginia Supreme Court held that the fact that we have geriatric parole is a meaningful opportunity for these juveniles who've been sentenced as an adult. That case was not that particular case, but that issue was taken before the U.S. Supreme Court on a Virginia case called LeBlanc versus Mathena a couple of years ago. And the U.S. Supreme Court at that time upheld Virginia's ruling and I pronounce it in hell, as far as, but it was based on the deferential treatment that a state court's ruling is given in a habeas proceeding. And in the footnote in that particular case, they went on to say, had this come up on a direct appeal, we may very well have decided this differently. And so there are these cases that are pending, and they have been pending in the Fourth Circuit for a period of time, and they're probably pending in the U.S. Supreme Court at this particular point in time. And in those cases, a lot of those cases, these issues have come back, and the courts have ordered resentencing because the court cannot order that the Commonwealth, in this particular situation, institute parole proceedings. So VACA remains committed to truth in sentencing, but we do also understand and recognize the disparate way in which geriatric parole addresses this particular issue. If you've got a 17-year-old who is receiving a life sentence, he's got to wait 43 years before he's going to be eligible for geriatric parole. A 40-year-old man who is sentenced to life in prison has to wait 20 years until he's eligible for geriatric parole. Again, federal courts are taking action in this area, and they're ordering resentencings. And resentencings are very difficult to do. After years and years have gone past. We think that this is basically the best option that's available to us. And for these particular reasons, we support SB 103.
Okay. Anybody against it? I guess not, right?
Mr. Chair.
Yeah, Senator Dietz.
Move to report the bill.
All right, it's been moved to report Senate Bill 103, seconded. Without further discussion, all in favor of the motion to report, vote aye. All opposed, vote no. The clerk will close the roll.
Ayes 11, noes 2.
Congratulations, 11 to 2.
Thank you, Mr. Chairman.
Okay, thank you very much.
Could we next do 242, Senate Bill 242?
242. Okay, Senate Bill 242. Senator Martin.
Thank you, Mr. Chairman. This bill attempts to close an incredible loophole. The law, a Class 6 felony for having sex with an inmate or someone who's incarcerated or on pretrial or with a probationer or a parolee and what have you, has been recognized under Virginia law as a Class 6 felony. Nothing, the code is silent on police officers who has somebody in custody or has arrested someone. And I guess this bill could be summed up as that there's no such thing as consensual sex in the back of a police cruiser. And New York City, there's a headline right here. 2 New York Police Department officers were accused of raping a teen under arrest. The charges have been dropped. They were dropped because there was no specific law against consensual sex between police officers and those in their custody. This bill just attempts to close this loophole in Virginia law.
Senator Dietz.
I've got a question for counsel. My understanding is that there was an offense of a sexual assault or rape of someone who was in your custody. Does that not apply to a correctional officer in Virginia?
Well, we don't know all the facts of that case, but yeah, go ahead, counsel.
Mr. Chair, under current law, it does apply to correctional officers. Okay. The Patrons Bill expands it to law enforcement officers.
Right. Okay, that's right.
use of, correct. So my understanding is that the intent of this bill was to protect people for merely having their certification, not to create a situation where people can use that certification as cover for the use of marijuana that they're smoking recreationally. So if we put use, it protects their use, which puts them in a different situation under the law from someone else whose use is not protected. So just having the certification, I don't have a problem with that. If we want to create a special protection for people who have the certification, I don't have a problem. I do have a problem if we create a special protection for people who are using marijuana, because the tests for THC are sensitive enough to pick it up even if you are taking CBD, depending on the test. So that was my concern. So if we replace the use of with registration for, or whatever the right term is, just the fact that you're certified, then I don't have a problem with it. But I do have a problem when we're creating two different classes of parents.
Good afternoon. I'm Kim Ramsey, and I'm here with the Virginia Family Law Coalition. And we do oppose the bill for the reasons that have been stated well by Senator Deeds and Senator McDougal. The concern is we want this as specific as can be. You know, we don't want to open this up and for these. Well, we don't. I'm sorry, I'm misstating. We don't want these specifics in there. What can happen is just there's going to be one after another after another. And for instance, it's not always about something like drugs or something that's being used like this. Last year, there was a bill brought or I don't know whether the bill actually came all the way, but someone was approached from visually impaired parents. And they wanted that in as a specific, that you can't be, you can't be turned down for custody because of that. And it's all sorts of things, not just the use of marijuana or something else. It's already within the discretion of the judge. They can look at all of these things. It's unnecessary, and it's just opening a Pandora's box that we don't want to go there. No, we would still be opposed. Exactly,
Mr.
Judge.
Chairman, when we're looking at all these things, particularly dealing with medications, if a parent were to give somebody medication for which they had an allergic reaction and they determined that they continued to give it even after they found that, and that was the sole reason the judge decided to switch custody, we would not want to forestall the judge for being able to do that. So with that, Mr. Chairman, I'd make a general motion to.
If I could just close, the unique. I'm sorry, Mr. Chairman.
Right now, the judge considers the best interest of the child. It's a lot of different things the judge can look at. Why focus on this issue?
This one issue is unique because it's about the only thing I can think of that's a violation of federal law that is legal in Virginia. It is still against federal law, and that argument can be made in a custody hearing or a visitation hearing and say, you can say what you want, but this parent is violating federal law and should not have custody of this child. I understand the Christmas tree ornaments here, but I think this is the angel on top of the tree, the one unique thing that you would have to consider because of that unique situation where something in violation of federal law that is legal in Virginia could be used as an argument, and that's all we're trying to forestall.
Do you want to consider any amendment to try to fix it or not?
I don't know of any amendments that would fix that, but there could be no other unless you wanted to deal with something like that. Anything that's a violation of a federal law but legal in Virginia, you could word it that way. But
Yeah.
that's really what we're getting at here, and that's why this is unique.
Yeah.
There's no other ornament you can hang on this tree that fits that category that I'm aware of.
Okay. All right. Any further discussion? Is there any other anybody who would like to testify? Okay. Is there a motion? It's been moved and seconded to PBI the bill. All in favor of the motion, say aye. Punch aye. All opposed, punch no. All right. The clerk will close the roll.
Ayes 13, no 0.
Thank you, Senator. You did a great job.
Wow, thank you.
Okay. Just to make it life easy for you. 13, the bill is PBI 13-0. Okay, the next bill, let's see, where are we now? Senator, all right, who wants to go first? All right, Senator Hanger's bill, which is Senate Bill 59, is bye for the day. Okay, Senator Rivola.
Thank you, Mr. Chairman. I would like to first discuss Senate Bill 105, and there's a minor change in line 36, if you would like staff to read that change.
Okay.
Mr. Chairman, on line 36, after any history of, insert child abuse or.
Okay.
Thank you, Mr. Chairman. What this bill talks about is it goes to the best interest of the child as we discuss visitation issues when you're in a custody agreement. And under item 9, there are a list of different things that must be considered that a judge needs to weigh in making these determinations. We have added
Mr.
that
Chair.
an act of violence, force, or threat against an intimate partner or the intimate partner's child,
Mr. Chair.
or any history of child abuse or sexual abuse. We
Okay,
just, that's the bill.
Senator Deeds.
Senator Favola, I'd ask you why the things that you've added on lines 34 through 36 aren't already covered by what's on line 38?
Thank you, that's a very good question. We thought, and there was a coalition that worked on this, the Coalition of Family Lawyers, the Virginia Poverty Law Center, the Virginia Sexual and Domestic Violence Action Alliance. We felt it was necessary to articulate these specific criteria because they really were important in weighing custody and visitation issues. And in line 10, it's not definitive that the judge consider these. It's at the judge's discretion. And this group determined that these issues were so important, we wanted to actually articulate them in statute. Delegate Levine is carrying the House version and actually had some pretty compelling stories from constituents. The Sexual Assault Advisory Committee established by the General Assembly, a group which I had chaired and still serve on, heard testimony as well on the value and the necessity of adding these criteria.
Mr. Chair.